So we'll see what the ramifications of that are. Well, the announcement from the FBI coming just 3 days after officials interviewed Hillary Clinton, about 72 hours, as part of the agency's investigation. FBI Director James Comey saying that his department looked into past cases before making its decision.
In looking back at our investigations into the mishandling or removal of classified information, we cannot find a case that would support bringing criminal charges on these facts. All the cases prosecuted involved some combination of clearly intentional and willful mishandling of classified information or vast quantities of information exposed in such a way as to support an inference of intentional misconduct or indications of disloyalty to the United States or efforts to obstruct justice. We do not see those things here.
Joining me now is Lise Wheel. She's a Fox News legal analyst, and Bob Bianchi. He is a former head county prosecutor, a criminal defense attorney, and a trial attorney. Thank you both for joining us. Very busy day. Let's actually begin there. Lise, I'll start with you. Cannot find a case that would support bringing criminal charges based upon these facts.
Right. General Petraeus, he intentionally shared classified information with somebody who was not, was not able to get this information, did not have that classification information, was not able to get it, under violation of 18 U.S.C. 1924. So here, the argument that Comey would be making is that she did not intentionally share information with anybody that did not have that classification. There was no intent there, and the context was different from Petraeus. Yeah. So then we get into the non-intentional act, and that is the gross negligence act.
And we'll talk about that in just a minute. But yeah, we did hear him say, willfully, did not willfully do this either.
Yeah, Heather, actually, that's the one quote that I pulled out of his entire statement. I've been saying this since this investigation began. U.S. attorneys want to have a case that is lock, stock, and barrel that can be proven beyond a reasonable doubt to 12 people. 80% of the cases that have been brought to the Department of Justice under the Espionage Act in cases like this have resulted not in prosecution, and it is prosecutorial discretion to want to see a person that was intentionally doing something to harm the United States, and I agree with Lise completely. This analogy between this case and the Petraeus case is completely different. It was giving information to somebody who was going to disseminate that publicly, and there was an allegation of obstruction of justice.
So that is different.
It is different,
then what cases would they have referred to? Because this case really is unprecedented. I mean, this is a person that is running for President of the United States, a former Secretary of State. So how do you compare it to any cases?
It doesn't, because she's being sloppy, and this is what Director Comey said. Extremely careless, again, were the words that he used. Extremely careless. But what he's saying is there's no intent showing there. She's just being extremely careless. I guess it was expediency. She didn't want to have to go through all of this and whatever. But you can't climb in someone's head and say, what he's saying is you can't climb in her head and say there was anything intentional there to disobey the law.
But we know that she intentionally lied, though, because she said that these emails, all of the emails that she saw, they were not classified. We now know from what that Comey said that there were at least, over 100. There were 110 emails in 52 email change, and he went on to say later that she was specifically involved in sending and receiving 7 of those email chains.
Yeah, well, the issue here as far as the investigation is that these attorneys were smart. They brought her in for a 3.5-hour interview, and I know as an attorney that you don't bring somebody in there under these circumstances unless you're pretty confident your client's okay. The issue is about lying under oath or lying during an investigation, not to the public. And I would just say this, Heather, why I really respect Director Comey, who's got a tremendous reputation, is he specifically did not put politics into this. He did not take into evaluation that she was a presidential candidate. He did it as he should have, based on the facts, law, historical precedent, as if it were any person.
Yeah,
and I think he did a great job.
Honestly, competently, and independently with no outside influence. But do you really believe that that is the case? I know that he has this stand-up reputation that, he doesn't let anything interfere.
I believe that when they brought her in on Saturday and had that 3.5-hour talk with her, that they really had already decided what to do unless she lied to them then. That would have been a violation of what we call a 1001
that would have
violation.
Been a crime. So she can lie to the American public. That's not a crime, but she can't lie to them.
If she lied to them then, that would have been a crime. I believe, unless she lied to them then, they had already decided what to do. Do you agree?
I don't altogether believe she lied to the American public, but nevertheless, I do agree.
All right, we have to wrap it up. Thank you both. We really appreciate your insight. John?
So President Obama is teaming up with Hillary Clinton for a speech